let me begin with a deep breath. 14 days of wait, and with some hiccups. Finally on the pitch. However, Milords, we are dealing with Kashmir, Milord. If one goes to Kashmir, Milord, 14 days are not enough. I think Mr. Zafar Shah will vouch for that. And even a month will be, Milord, less. There's so much beautiful scenery and so much beautiful and nice people, Milord. And a nice culture. So what one thing is there, Milord, with this proceeding, the learned councils, what name? When you play a match on the pitch, then you don't watch the scoreboard. Oh, you forget it. So one thing is clear, Milord, that the learned councils on my right, Milords, they have very ably, Milord, put forward the case for the rights which the people of Kashmir, or at least some of them, feel vest in them, and the desire to see the continuance of 370. Nobody can say, Milord, that the lawyers who are not from Delhi, they have taken full care, Milord, of the interests of those who believe in the continuance of 370, and even the world who is watching should see, Milord, that the emotions with regard to Kashmir are not only running in the veins of people of Kashmir, but the whole of the people of India. They are concerned with Kashmir. One way or the other, that's a different matter. Which way the judgment goes is another matter. But we are all concerned with Kashmir. That's the stature of Kashmir, Milord, in the hearts of all the people, Milord, 1.40 crores. Milord, the other aside is, Milord, that I was wondering, Milord, taking a cricketing analogy, just a little aside, Milord, that when we walk into the pitch, the opening batsman, Milord, is one finds with the guards and thigh guards and elbow guards and helmets nowadays. But our Milord, opening batsman, Milord, the learned Solicitor General, when he walked up, he did not walk up any pads, etc. Milord. And that reminded us of the period of Sunil Gavaskar, Milord. We never had wear, Milord, the head caps and all that. Only the skull cap was there. So he didn't start by saying, Milord, that these constitutional orders carry the presumption of validity, Milords. These are all available, Milords, to the state to stand up and say, which your lordships, of course, keep in mind. One, that there is a presumption of validity, Milord, which they have to, the burden is on them to show that unquestionably, undoubtedly, the only conclusion is what they are conversing for. The second principle, Milord, is that if there are two views possible, Milords, with regard to 370, sub Article 3, then that view should be adopted, which sustains the exercise of power rather than it defeats that exercise of power. So the burden on them is to show that what they converse for is the only view possible.
Mr. Dwivedi, which IA are you appearing in? I'll be just like.
I'm appearing, Milords, in writ petition 1070 of 2019. And I'm sorry, IA number 84479 of 2022, I apologize. In writ petition 1070 of 2019 and writ petition number 1162 of 2018. Both of them are by the most popular PIL petitioner in the court today.
Ms. Manohara Sharma.
No, listen. Nowadays he is not that popular, Mr. Upadhyaya.
Oh.
Your arguments, Mr. Dwivedi, have to be very brief.
Mr.
My argument was?
Arguments have to be very brief. Because Mr. Upadhyaya feels that a delay in justice is occurring, so therefore there must be very, very concise arguments and finish. That's his view in public domain.
In fact, one question which has troubled all of us is when my Lord the Chief Justice asks how much time you will take. So, now being towards the end, it won't be too long, but let me see how crisp I can be. So, these are the two fundamental basic principles. And in constitutional matters, it's always possible to take two views. Even if the basic structure doctrine was 7:6. So these are all always highly debatable. Ultimately, your lordships have to decide which is a better proposition to take place. Just as in that case, what tilted the balance was that if an absolute power is granted to amend every part of the Constitution, then many of the fundamental values can suffer destruction. So therefore, that caused the tilt. But there also, lordships did not say basic structure cannot be touched. It can be abridged, but not destroyed. That was the concept. So coming to 370, lords, I have some divergence from what Mr. Salve submitted. It's not in opposition, my lord, to what he generally submitted, but some divergence. Yes. In our camp, my lord, fortunately, there is little divergence and contrast. Unlike, because those who are claiming that that's the only submission, I find a lot of contradictions amongst the lawyers. Some saying something, something trying to say quite opposite to that. But that apart, my divergence is about the character of the power of the president. Mr. Sibal said it is executive, president's power. Mr. Salve says it's legislative. I say, that this power is a constituent power, much wider than Article 368. The fact that it is vested in the president is for the special reasons which existed when it was framed. It's a constituent power. A power, because the lordships in the 5 judges' judgment say, Puran Lal Lakhanpal 2 probably, that modify is very wide. Efface. You can say even 136 will not apply. Ordinarily, independence of judiciary, if anybody touches 136, it will be struck down as violating basic structure. So the power to modify and accept under D is very wide. Well, there are 5 kinds of constituent powers in the Constitution.
Yes.
But the first was the original constituent power in exercise of which the Constitution was framed. The widest term, you could have framed anything you wanted. Whatever kind of federal structure you wanted. The second one is the ancillary constituent power. That is something like Article 238 was that for certain period of time, the federal structure stands suspended, the central government will control Part B states and develop those structures and ensure that it comes up at level. And that's very important. It doesn't apply to Kashmir, that's one thing. But the idea was that the central government should take steps to bring it up at par, those states, Part B states. The other was 306 in the chapter of free trade and commerce, where certain states were very much interested in continuing with the power of taxation, particularly Travancore, Cochin, because being on the port, their entire income was found based on the export and import duties. So therefore, 306 permitted for a certain period those states to impose, levy and collect tax. The 370 is another power, of that kind. All three, the purpose is to have some time period, some temp period, so that bring it to the level of the normal federal level. Asymmetry, is completely different concept. Some tribal area may be lagging behind, some state may be lagging behind, some state may have some special features, so you may for some time allow them certain special treatments. All these detailed provisions which are read out to your lordship, 371 G2, dealing with the Northeast and Andhra Pradesh, Mizoram, etc. They have nothing to do with bringing at par. That is to protect the tribals and so on. But these three articles stand on a different footing, and their objective is to give a certain breather, certain time, so that in due course, of course, the manner of alignments, how it will be brought in are different. So
Article 238 was not limited in time, right?
No, but ultimately by 56 it was
right. It was
intended to be a permanent feature. That's what I mean to say, Rose. Under the policy documents, which I will read out to your lordships to the relevant portions only, would show that the idea was because the different Indian states were in a different state of development. Some were so small they could not hardly afford to have a legislature, etc. I know. So state structure could not be supported by them. So like even in Himachal Pradesh, they had to be collected and put in one, so many union of states had to be carved out, many small states had to be just merged. They could not afford to have a state. And though even those who formed a union, they hardly had a constitution, that it required a time period to build a constitution for the United States. So for various reasons, in various phases, things developed. And so finally, the federal structure which was formed, even at that stage, there were pulls and pressures. So certain compromises struck. And these three articles, therefore, are ancillary constituent power. They are continued. This is very significant with the process. For example, for 370, the process which started with the framing of the constitution, it was understood, that this is to last. They don't fix a time period, though they have put it in part 21. No specific time period is put there, but it is expected, that in due course, as Nehruji and Gulzari ji said in their speeches as prime ministers, that slowly B1, B2, and D will be used, and the alignment process will happen, and slowly a time will come where really nothing remains. Then put them at par and finish it off. This is meant, therefore, to slowly align it, bring it at par, and terminate it. So it's that continued process, and that's why it's an ancillary constituent power. The third is, the amendatory constituent power in 368. And in the context of 368, I will just give your lordships the paragraphs, separately, of the different judges, who held that the power under 368 is constituent, and that's why Golaknath was overruled. Though ultimately in the process, what was created was the super Golaknath. So the limitations were in Golaknath were only fundamental rights, but now it's a much wider domain. Essentially, what I rely upon on those portions where the ordinary law and the constituent power have been distinguished. And the distinction pointed out is that where you are amending the constitution, constitutional provisions, then that power is constituent power. Ultimately, 368 so therefore, and if you compare 368 and 370, located in the constitution in proximity, the width of amendatory power, at least as the law stands now, basic structure cannot be amended there. But here, so far, nobody has paid any heed to the basic structure. 35A has come in, and a whole lot of things. 136 was applied much later. So, Comptroller Auditor General came much later. So, all the basic fundamental features, they were missing. So, it's much wider than the amendatory power. So, it cannot be described as an ordinary executive power of the president, or even a power which is legislative in the nature of an ordinance making power. So what your lordships deal with today is a constituent power. And this constituent power, is laced deeply with elements of act of state. To illustrate, Article 370, sub-article 3, if the proviso was not there, which lasted for a few years from 51 to 57, then it is nothing but an act of state. Anytime he could have said end to 370. So the constitution makers, instead of leaving it for the state to act supra-constitutional to annex the state, they provided a particular procedure to avoid that happening, so that it happens as far as possible, with concurrence, consultation, recommendation, and a period of time lapses when it is felt by the people as a whole in the country that the time is ripe. That's what Iyengar said. When the time is ripe, Jammu and Kashmir will stand at par. So who decides when the time is ripe? 373 will not continue because of emotional reasons, sentimental reasons. As my Lord Justice Gawai had said, well, this case can't be decided on sentiments. Sentiments are on both the sides and of variety of kinds. So those sentiments have to be kept outside the door. It is the president, my lords. And the president means the council of ministers and ministers who are collectively responsible to the parliament.
Do you call this ancillary constituent power because the president has the power to amend the constitution and its application to
I
Jammu?
say ancillary only for this reason, that it is a continuation of the process which began with the insertion of 370. In that sense, I am saying ancillary. Otherwise,
But it's constituent according to you because any power by which you can amend the constitution itself.
Yes.
Because it says that the president can, can determine which provisions of the constitution shall apply with exceptions and modifications. So the president is vested with the authority to apply or refashion the provisions of the constitution in relation to the state of Jammu and Kashmir.
yes, sir.
Consent, concurrence is a separate issue.
That's right.
Therefore, it partakes of a constituent power according to you.
That's right. So not only what the Constitution of India will be in relation to Jammu and Kashmir, because on that depends what the constitutional ambit will be of the J&K Constitution. As the Lordships had pleased to observe, based on their own Constitution of Section 5, as this expands, that contracts. So therefore, this power is having a direct impact on the reduction of the scope and ambit, the play field for the J&K Constitution. So it's not only an unusual power, but a power which is of a very wide scope and wide impact, wide consequences, wide ramifications for the whole of the country.
Very significantly, any modification cannot be brought about by the legislature of J&K or under the Jammu and Kashmir Constitution.
Right.
Modification has to be brought about within the rubric of the Indian Constitution.
Indian Constitution. That's right. And one of the proclamations, the first one of the Yuvraj Karan Singh, as he then was that this Constitution of India will define the relationship between the state and the union. 25th November 1949. That's very important. I'm not reading it, you'll also have seen that. J&K Constitution was not there. So this Constitution will define, that's a very potent expression, my lords.
It is.
So therefore, my lord, it's not an ordinary legislative power, and when you, I'm so sorry.
Two of the unit. Say if entry 82 of the union list is applied, the J&K, there's no provision in I just took 82 not for
Yes,
any
yes,
reason,
I
I just
understand.
picked up one entry.
Yes.
That there is no provision in the J&K Constitution by which they can say that, look, we don't want 82 hereafter.
That's right.
Because the application or non-application of provisions of the Indian Constitution has to originate within the Indian Constitution.
They are asking for anything is insufficient, inconclusive, of no avail. Of course, I'm not belittling it, but after all, one state and union relationship is involved. If a state is asking for something, of certainly the union should consider and give it a thought and possible accept. But that's a different dialogue. It's not talking and speaking to each other, as Mr. Gopal Subramanian was saying, and lot of talking and speaking and whispering also goes on in political sphere, in every law when it is made. Sometimes they meet outside in the lobbies, Lord, and sort it out, Lord. Sometimes it goes to select committees and so on. So talking and speaking and whispering and all that is neither here nor there. That doesn't result in a compact. If something, two parties go outside and sort it out, and then the bill is passed with some change or without changing. What happened when 370 was being tabled? Your Lordships has seen, there was hardly any discussion. Because the government, my lord, said that do not debate too much because advantage will be taken by the warring state across the border. Before UN, there was no debate. And in 1952, Mr. N.C. Chatterjee said that at that time you did not allow us to speak, saying that Pakistan will take advantage of it. But now in 52, then he put up questions. Of course, Nehruji answered it. These are only not critical of anything, look, that one has to place oneself in those times, and it is difficult for us to go on a flashback in these cases. They're difficult times. So he answered it then, but those questions were not put. So one can't put reliance on the speech of Mr. Anger or this or that speech of Mr. Sheikh Abdullah. They were divergent interest also, clashing interest also at that time in play. It doesn't detract from the stature of any of the political leaders. Sheikh Abdullah was a great personality, political leader. Nehruji was a great leader. Sardar Patel was a great leader. But what of that? Churchill was a very great leader. But after the Atlantic Charter was hashed out on the seas with President Roosevelt, when he was posed with the question, what about India? He said, this charter doesn't apply to the India. They are colonies. It is only meant for France and Poland, etc., in Europe, which lost freedom and their territory to Hitler. So they're all great leaders, but they grapple with their situation in the interest of their nation. And in this case, when 370 was being drafted, please bear this mind, my lords, these circumstances which were prevailing then. And one more very vital circumstance. We have been hearing, lords, and sometimes I've read through the Constituent Assembly debates also, many books also. They all said war is going on between India and Pakistan. What was that war, my lords? Somehow, my lord, we are still, the lips are pursed and we don't want to speak about the truth. Who was the Supreme Commander, my lord, of the Armed Forces? Auchinleck. All the three generals of India were British. All the three generals of Pakistan were British. What was this war, my lords? Churchill had, my lord, designed there itself that India has to be partitioned. Geopolitics. This war was a British war. They created it on both sides. The raiders came from where? Northwest Frontier Province. After 2 terms, Mr. Cunningham, who had been governor in Northwest Frontier Province, he was brought back in July, just before the elections, referendum. The raiders were trained, sent on trucks with weapons of army. Pakistan army had just been split from India. And the biggest, starkest example is, Lord, who was fighting, Lord? What is this POK today? 2/3 of POK is Gilgit-Baltistan. And who fought the war there, Lord? Not the raiders. It was Major Brown, who was the regent there. He was posted again in July, just before that, by Cunningham. And this is a book, Lord, Mutiny. He killed all the forces of Maharaja. Ansar Ahmad was posted there, Lord, and he was arrested. And he, in 4 days, Lord, he hung the flag of Pakistan and he had handed over to Cunningham He sent some Mr. Alam from Pakistan army and he took over Gilgit-Baltistan. Where is the war with Pakistan? It is British. But if we close our eyes to all these, then it is the raiders fighting across floods. Raiders could not by themselves come up to Srinagar. The war had reached almost this Kardu and Kargil and to that closeness to Tibet, Leh. So it was a war of a different kind, but nobody could say it because Mountbatten was there, Lord, as the Governor General. Again, must have the leaders, our leaders must maybe having some reason that even though Lord Jinnah said, I will not accept any British Governor General, but the party said, no, we are ready to accept Governor, you continue with Indian Governor General. So what is this war? Governor General, and not only this, when the war began, Lord, they constituted a defense committee of the cabinet. And Mountbatten was made the chairman of that. So it's an excellent situation. Lord Mountbatten is the chairman of defense committee. Auchinleck is the supreme commander of forces. All generals are British, and one Britisher is mutinying. And when he returns to England, he is given the medal of the British Empire. So that's not the position of the war. So when you read the Constitution and 370, please bear in mind these things, Lord, in what circumstances our leaders were moving through. And when we were, Lord, about to push them back, Lord, and back and recover the territory, they deliberately stopped the war at a point of time and got the reference to the United Nations. Because if you had gone up to Mirpur and behind, then that connection would have been off with Gilgit-Baltistan. Now, these are hard facts, Lord. Nobody can dispute it. It is in these circumstances, Lord, and what was United Nations? The same very power which for geopolitical reasons, the US and UK, which wanted to partition India, they were the arbiters. Fortunately for us, Lord, Pakistan refused to vacate POK. So that resolution is dead. There's no need talking about United Nations, but at that time, look at the enormity of the situation in which 370 has been. We can't interpret it, therefore, Lord, with a tool of interpretative toolbox. Maxwell cannot answer this. Bennion cannot answer this. Grace cannot answer all this. None of the judgments so far which have been delivered in this court are helpful at all, Lord, to reach a conclusion, except Sampath Prakash, Lord, which dealt with to some extent with the situation after the expiry of the dissolution of the Constituent Assembly of Kashmir. That and that alone. The rest are all in different contexts, principles we can help, take help of. But this situation, if lost sight of, creates problems, Lord, at both ends. You accept their contention, then this becomes permanent. There is a proviso under 368, we can't amend it. Go by the route of 370, and 370 is permanent, and therefore, Lord, we are left at the mercy of the local vested interest, which does not always coincide with people's interest there. So you, therefore, look at the consequences of both sides. On one side, if you accept our submission, the right of the people of Jammu and Kashmir gets expanded. And they don't suffer blood. Right to property is a matter of the rich and the neo-rich blood. The poor people, they're hardly 19(1)(f), they're hardly concerned. But even those smaller people who have small houses, etc., so certainly it has meaning. But then 300A is there, which virtually subsumes, now it's a human right under the Constitution. So nothing is lost, not even 19(1)(f). Nobody can confiscate because of 300A. So 31 and may not be exactly at par with 31, but substantially it is there. So nothing is lost. They are put at par. The basic structure of federalism is protected. I don't know how a lot the submissions were made that federalism is affected, to keep it in mind. This is federalizing at par.
According to them, federalism is affected because you reduce the level of a state to a union territory.
Unless you accept asymmetry is basic structure, then they are affected. Asymmetry is never a basic structure. They are for special conditions. Asymmetrical dealing with a state.
Mr. Dwivedi, this matter apart, the existence of a state is a very vital element in the federal.
I'm not on the state.
The existence of a state, the continued existence of states is integral to federalism in India.
Well, sir, I will humbly request your lordships, I'm dealing with CO 273. 272, which deals with 356, that has been answered by the Solicitor General, or whatever, your lordship will consider that. Supposing, my lords, for a moment, for my submission, please assume, my lord, that 272 and the act is not there. Because it's my case, what I am conversing for is, irrespective of 356 invocation and Article 3 invocation, 273 is sustainable on the anvil of 370 main part itself. It says that Parliament has recommended and we are passing this. Obtaining the recommendation of consume tomorrow. So far as involvement of Parliament is concerned, it comes in two ways. One is
Mr. Dwivedi, just to sort of break your leg a bit, you spoke of there were 5 constituent powers.
The fifth one I have mentioned.
We got third. We have the original constituent power by which the constitution was framed.
Fourth.
Second was ancillary constituent power. The third was amendatory constituent power. That's the third.
The fourth, my lord, is like the provisions like Article 3 and 4, where amendment of schedules relating to states and their structure, etc., Article 3 and 4, they can be altered. And by a law of Parliament, and it is provided that they are not to be treated as amendment under Article 368.
Then can that be treated as a constituent power at all if it's not an amendment to the Constitution?
No, so they are amending the schedule to the Constitution. Their levels are different.
But the Constitution tells us that it's not really an amendatory power.
So therefore, I'm saying that these are the 5 different ways in which the power has been conferred. This is one another way
All right. That you
where
get
they
sort of
say that you
bifurcated.
can make a change in the constitution. Because my postulate is that every change in the constitution itself, if brought about, is a constituent power.
All right. That's the fourth.
And the fifth is, my lords, Article 1C, where this court has held that if you acquire some other territory, then it says I'm sorry, Article 2, my lords.
Two, not two. Yes.
2. I'm sorry, it's Article 2.
Parliament may by law.
Yes. Admit new states on such terms and conditions that things fit. Again, my lord. Very wide. So while admitting, my lord, A, B, or C country, let's say, my lord, some bordering city of China, my lord. They are very interested in naming our cities, my lord. If that is admitted, just aside, my lord, lighter way. So if it is admitted, my lord, then the terms and conditions can be fixed.
Therefore, your argument is that the exercise of the power under Article 370(3) is a constituent power exercised by the
So
President.
your lordship's judicial review has to be on that basis. And it's when your lordships expound 370, it has to be with that in mind, my lord.
So the level of deference would be much higher than even the level of deference to an ordinary piece of
legislation. Executive order, then Wednesday principles and all those things will come in. Whether your lordships will bear judicial restraint, that's the other side of it.
That's the exercise.
Yes. If it is legislative, as the lordships put, my lord, Article 14, how it will come is whether it will succeed or not is quite another thing, but amenable is the lordships. But if it is constituent power, my lord, which is continuing and is part of the constitution making, part of federalizing. This is part of constitution making, part of federalizing Jammu and Kashmir at par with other states. I will read two state policies, one place before the Constituent Assembly by the State Department and the other the speech of Sardar Patel, where they spelled out the policy. This was a departure from that policy. And departures, my lord, are not permanent. Can never be permanent. The policy is states, that is the Indian states and the British provinces under the Government of India Act should be brought at par, at equal level. That was the policy. And placed in October and November 49, just before the adoption of 370. So 370 was a departure being made because of circumstances, political pulls and pressures and so, and the circumstances which I narrated. So therefore, you have to therefore consider this as a continuing process which was meant to be terminated, and 75 years is a pretty long time, lords, for federalizing Jammu Kashmir at par with other states. That means that the power was rightly vested in the president and was properly exercised by them. It was not that in 1957, one may ask not that if my contention is accepted, then immediately after dissolution of JKCA, the president could have terminated. Yes, he could. It's a high political policy, brothers. It's an act of state. There were some states where forces were sent. That can't be questioned, that how Hyderabad was brought, how Junagadh was brought in, how a referendum was done. All those things are in the past and they were act of state. Mr. Sibal said that had there been another route, act of
state is executive, right?
So executive, nothing prevents the Constituent Assembly from putting a power in the Constitution itself. So that, my lord, it is what was expected was that the Constituent Assembly, when it sits, it might well take a decision that please align us at par. The recommendation, my lord, part of it, the proviso, was merely to enable the JKCA to look at the advantages of the federation.
Dwivedi, what was pointed out by the other side was,
Yes,
when you frame the constitution, when you enact the constitution, then you're probably exercising constituent power. What happens thereafter will be either in the realm of legislative power or the executive power. If we go by this.
so that's not right, my lord. And that's my contention. They are not correct in that. It's not always, then 368 law is not purely legislative and executive.
Now, you are equating 368 also to constituent power. Yes, by saying that it is also a constituent power. That way it is. Whenever you will be amending the constitution, you will be making changes in the constitution. But that exercise cannot be equated with the constituent power for the simple reason. Constituent power has the power to go from a scratch, from 0 point.
Not necessary, my lords. A mandatory power is constituent.
Yes, a mandatory power is certainly
So this
there.
is a mandatory, my lords. You can much wider.
No, the question is not that. The question is, can the mandatory power under 368 be taken to the level of constituent power as to go?
I never said that, my lords.
You're not saying that.
No.
So what you are saying, therefore, they're really speaking, there's jurisprudentially, there won't be any difference.
There would be, my lords. The nature of power is completely different. My lord. That has to be realized. An executive power of the president is, for example, he recommends, my lord, financial bill should be passed. That's a different kind of power.
That's correct.
So the president has a whole lot of role to play under the constitution. All roles are not at par. For high policy reason, this was given, my lord. No, but this proviso to 368 is because the government, my lord, of India did not want, my lord, to go through the route of 368 every now and then. So if you want to, my lord, do away with 370, go to 368, then 2/3 majority, and then you maybe somebody will say state is affected, so ratification by majority of states. So an easier, my lord, because the policy was to put at par. Therefore, my lord, it was, since the policy is given, alignment is the question. Alignment may take such time, my lord, as the circumstances permit. Nobody can predict how much time it will take. So, and this was provided here. Keep also one more aspect in mind, my lords. The framers of the constitution knew that a president of India is a continuing office. It will not lapse after any point of time. Whether it is part of basic structure or not. But even if it is not, nobody expected that the President of India office, high office in which the executive power vests, will vanish. So it was a continuing power. They also knew that Jammu Kashmir Constituent Assembly is an ephemeral institution. So they had two institutions, one permanent, one ephemeral. They are being brought into a relationship in 373 with a notwithstanding. So now not an ephemeral expiry of an ephemeral institution impacts the permanent institution of the president. That can never happen, my lords. If that were the intention, what was so difficult in 370 to add a few words that with the expiry, my lord, of the JKCA, if I may use this short JK Constituent Assembly, then, my lord, the main power will also lapse. The framers are very well aware of cessation of certain exercise of power after certain period. Be it 356, 352, ordinance making power, place in 6 months. If you don't place, it will lapse. My lords have dealt with, my lord, in Krishna Kumar Singh, my lords. Even 249. So there are so many, my lords, situations. They are aware. They are casting the languages of different provisions with this expression that it will cease for different reasons in different cases. Why is it that they are refraining here? Certainly, my lords, it could not have been in their mind, my lord, that this will remain for all times to come, my lord, till eternity, my lord. The relationship of Jammu and Kashmir, my lord, state as a federal unit with India will remain different for no reason whatsoever. And as my lords had put a query to them, if I may just adopt that. Supposing, my lords, through the route of with concurrence and consultation, my lord, everything has been adopted. Why do we want to keep this relic? For sentiments, my lords. So it has to go someday, my lord, somewhere. And what is it that remains today, my lord? It may not be a shell, but close to a shell. And my learned friend Zafar Shah said, my lord, we have sentiments. Yes, we understand that. If I live for too long, my lord, with a particular provision, my lord, there will be sentiments, my lord. No difficulty, my lord. We appreciate that, we honor that, we respect that sentiment. But equally, just a human life, my lord, the time comes when you have to bury it. We have emotions, we have sentiments, but we have to bury, my lord. We have to cremate. So that's what, my lord, is in mind, my lord. That please, therefore, my lord, your lordships are acting as a part of a constitution making process. This adjudication is not apart from, my lord, completely disjointed and disregarding that process. Most of other things your lordships have already noted, my lord, this temporary here, temporary that. Right? They say marginal note, somebody says temporary is only object, my lord, not the time period. This is not the way, my lord, the lordships in Bombay have construed. Sometimes the lordships take help of the marginal note, sometimes the lordship doesn't, my lord. But here, my lord, the conglomeration of 370 along with all other provisions originally there. I'm excluding the special provisions. All the provisions were temporary. Somewhere, my lord, time period was fixed, somewhere time is not fixed. But all intended to lapse. There are temporary provisions elsewhere also, like 306. So they are meant to go. Don't hang on it. Nobody hangs on a body which is just a shell. It causes only those some. I can understand people with good intention. They respect that emotion. There will be a host of other people, who will take advantage of that. And in Kashmir, they have taken it. There have been time and time again calls for plebiscites, independence. In fact, in 1964, just before his death, the Prime Minister Nehru, he had sent Sheikh Abdullah, brought him back as Chief Minister, sent him to Pakistan with a message that you be a bridge between India and Pakistan. And he was going to POK when Nehruji died. Unfortunately, he expired. So I had to return from here. But I mean, that emotion which is created at that time in 52, 53, why will a person be kept in a jail for 18 years long? He suffered, yes. He contributed to India, but he stood also with his own emotions. We all respect all those emotions. Nobody condemns any emotion in human life, in a nation's life, in a state's life. These emotions arise and die. So, for emotional reason, my lord, 370, I think it's time to bury, and that's what was intended when the framers brought in 370, and that's how it is. 373, therefore, not CO has to be upheld. Now look at it once more. We are like 7 men and the blind men and the elephant. So we are all putting our perspectives before our lordships, and the lordships will kindly receive that and find out what is the whole, integrated whole. Seven is the smallest question. The lordships have been putting a question, so far as J&K Constituent Assembly is concerned, there are only two provisions. 372 and 373 proviso. In one, JKCA doesn't come. As my Lord Justice Khanna had pointed out, it is between executive and executive. The president and the government of state. Now kindly see, why is there, my Lord, a difference between the language of 2 and 3? The first point is, my Lord, that the proviso refers, when it refers to Constituent Assembly, my Lords, of the state, it refers to clause 2. Recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary. Now, Sampath Prakash has very positively held, my Lord, that that is dissolved, matter ends, power continues. Now, it is the same Constituent Assembly which is contemplated in the proviso, not different. So, on a parity of logic, my Lord, that judgment, the reasoning of that judgment, of course, they were dealing only with 2, not 3. So, in that sense, it is different. But the logic on parity, my Lord, is available. And therefore, I submit, my Lord, that concludes the matter virtually. Sub-article 2 is dead, defunct, but sub-article 1 continues. That is Sampath Prakash. Likewise, proviso is defunct. The main part continues. And my Lord Justice Call has, my Lord, in that Shah Faisal case, applied stare decisis. The doctrine of stare decisis, of course, is not an absolute principle. But in this case, an attempt was made. Without success. Now that apart, not kindly see why 2 says if the concurrence of the government of the state referred to in 1B2 or second proviso be given before the Constituent Assembly for the purpose of framing the Constitution of India is convened, it shall be placed for such decision. The word is decision here. That's right. Why it is decision there and recommendation here? Perhaps not. There is one reason which I wish to place, and if it commends to your Lordship. It is decision here because, my Lord, what is being considered by the Assembly is the concurrence given by the government of state. Concurrence, if your Lordship comes back, my Lord, to the first to B2. Such other matters in lists with the concurrence of the government of the state. The concurrence is of the government of the state. And the decision is to be given with regard to the concurrence. No decision is to be given with regard to the order passed by the president. The presidential order, whether it collapses because of the decision, is a question which is not arising, hypothetical question. But the decision is JKCA is a superior body to the government of the state. Therefore, the word decision has been used. When an order passed by a subordinate goes before the higher authority, then it is either a decision or an approval. The concurrence of the government of state of JK goes before the JKCA. Therefore, the expression used is decision. But when it comes to the proviso to 3, The president is not subordinate to the JKCA. He exercises the sovereign democratic power of the Republic of India, which is constituent in nature. There are two constituent powers in play, one superior, one subordinate. Therefore, the expression is used as a recommendation. A recommendation of a inferior authority, when it goes before a superior authority, can never be binding. That also if the body is a temporary body.
So according to the word recommendation in the proviso, refers to the existence of a recommendation and not the nature or the content of the recommendation.
That's right. Because I'm putting a question to myself, not supposing the JKCA had recommended a particular provision or particular structure for the executive or for the legislature of the state. Or let's say suspension of fundamental rights for. Will it be open to the president or not as a constituent body to say no? How can it be forced upon him? And he said you will suspend, delete part 3 for Kashmir. Hypothetical. Part 3.
Tomorrow, for about a little while, there's a matter before Justice Call sitting in a 3-judge bench. That won't take very long, and thereafter we'll resume immediately. Then. As soon as that,
5-10 minutes.